Okay, we're going to go through some of these chapters, and I am now in the living room, you can tell. This old couch. All right, chapter 12. Only kings, monarchs, dictators, and United States federal judges is the title. So, opening statements were going on in the Watergate trial, but at the White House, discussions were being held for the inauguration planning. It says the subject, sorry, I got distracted there for a second. The subject drifted into the question of lifetime tenure for federal judges, which they were trying to find a way to have a constitutional amendment to get rid of, and eventually to get rid of for Supreme Court justices. And it concludes this little aside with, no one had in mind the subject of abortion when questions about the limits of judicial power were being kicked around in January '73. No one, that is, except the 9 justices who were still trying to figure out how to deal with Roe versus Wade and Doe versus Bolton. It went into a long discussion of the relationships between the Supreme Court justices and their clerks, because one of the clerks, Hammond, turned out to be varied. He was the clerk to Powell. He actually was Hugo Black's clerk when Black died, and Powell kept him on. He talked about the first Jew appointed to the Supreme Court was Justice Louis Brandeis, who served from 1916 to 1939 and instituted something called the Brandeis Brief, which is a document identified by its heavy reliance on societal data as opposed to the more traditional citation of dry legal authorities. Under the Brandeis model for law clerks, young lawyers were selected and trained to assist the justices in promoting sociological jurisprudence, mainly by paying close attention to non-legal factual data in support of an opinion. Brandeis then encouraged his clerks to join academia after their clerkships to spread the Brandeis gospel toward the next generation of lawyers. And Hammond fit this mold, but didn't go on to academia. He ended up clerking for Hugo Black. And interestingly, Hammond had a stutter and other problems. He was picked because of those problems, not despite of them, because Black saw himself kind of as a redeemer of the underdog or those with disadvantages. He said, I don't pick my law clerks for what they can do for me, I pick my law clerks for what I could do for them. Then it says 3 months after Larry Hanman was hired, Black resigned due to an illness and died a week later. And then, as I said, he ended up with Powell. There's a paragraph here I'd like to read. Powell was in no hurry to jump into the debate that had broken out within the court over the abortion cases. But on June 1st, the Thursday following the first Watergate break-in and the casing of George McGovern's headquarters, Powell wrote a memorandum to the conference, the formal manner to eternally address all of the justices, indicating that he was prepared to take part in the abortion cases. I have been on the court for more than half a term, he wrote, and may be that I now have a duty to participate in the decision, although from a purely personal viewpoint, I would be more than happy to leave this one to others. Then, as it turns out, Powell told Hammond that he had pondered this problem during the break and had come down on the side of a woman's right to an abortion. Hammond remembered being quite surprised but pleased because he agreed with Powell. Then a critical turning point happened. At the end of that first week of October, Friday, October 6th, Powell sent a memo to Hammond about a cert note that Hammond had prepared on a Connecticut case known as Abeal versus Markle. First decided by a 3-judge panel in April '72, Abeal declared Connecticut's 1860 abortion statute unconstitutional. Hammond's cert note was his evaluation of the certiorari briefs requesting a review of the case in the Supreme Court. Hammond thought that the opinion especially well reasoned and that it might be of interest when deciding Roe and Doe. The importance of this relatively obscure Connecticut proceeding and the ultimate outcome of the abortion cases cannot be overstated. Powell was intrigued. I have just read your cert note in 7256, Abel versus Markle, in which Judges Lombard and Newman, Clark dissenting, struck down Connecticut's 1860 abortion law. He wrote to Hammond, "When we come to decision time in the pending abortion cases, keep in mind that we may wish to look at the Lombard-Newman opinions." Then Abel 2 was heard, and Abel 2 would become the Rosetta Stone for unlocking the secret of Roe. So going to those background judges now, it says, first, for Judge Newen and his clerk Hurwitz, it was a given that a woman had a fundamental, constitutionally protected right of privacy with respect to intimate family decisions, including the right to terminate an unwanted pregnancy. The Supreme Court decisions in Griswold and Eisenstadt versus Baird, allowing family planning through the use of contraceptives, they reasoned, could, by simple extension, support a woman's private right to choose whether to keep a pregnancy. Little discussion was needed on this point from their perspective. So the question became, did the state ever have a sufficiently important interest in protecting the fetus to justify an invasion of the woman's fundamental right? If it did, the interest had to be compelling, that is, clear, established, and without an argument. Newman and Hurwitz thought the interest of the fetus was far from clear or well established. People, theologians, scientists, doctors, ethicists, disagreed on what it was when life began or when there was ensoulment, and consequently judges varied on its legal status. Compared to the recognized right of the woman to choose, the fetus's rights were a matter of diverse personal judgment. So Newman expanded and decided to address a quote-unquote gruesome question posed. You consider here, the state earnestly urges us consideration of the situation where an abortion performed late in pregnancy results in a live birth. Evidence was offered to show that an aborted fetus had, on occasion, remained alive for several hours after an abortion operation. Would this present a situation where there was a compelling interest to support a ban on abortion? Newman thought perhaps in this instance it would. Newman seemed to be issuing advice to the Connecticut legislature on how to narrowly fashion an abortion law that could survive judicial scrutiny. If a statute sought to protect the lives of fetuses which could survive outside the uterus, he wrote, such a statute would be a legislative acceptance of the concept of viability. And it says viability, exclamation point. Here was a mention in a judicial decision of the idea that would become the cornerstone of Roe. While authorities may differ on the precise time, there is no doubt that at some point during the pregnancy a fetus is capable, with proper medical attention, of surviving outside the uterus, Newman wrote. And it is equally clear that there is a minimum point before which survival outside the uterus is not possible. What he was saying was this dividing line, viability, would find broader public acceptance, thus making it compelling. Few, if any, would argue he was postulating that a live birth or a fetus that could survive outside the womb could not be protected by the state. The very indisputability of the proposition made for a compelling state interest that could counter a woman's constitutional right to choose. So Blackmun's first drafts put the line after which the state could start to exercise some control as the end of the first trimester, and that became a dispute in the court, because nowhere does he state the basis for fixing it at that line. His clerk Hammond believed Hammond wasn't his clerk. Blackmun was the guy who wrote the opinion. So Hammond, who is Powell's clerk, was worried that if there was no reasoning to explain how that decision was arrived dat. It would hardly command public support. It seems to have been pulled from thin air. And Hammond, and I believe Powell, was arguing very strenuously for viability as the line. And there was all kinds of give and take and back and forth amongst the court, and the hard outlines of Roe were beginning to form, and yet no lawyer argued for these divisions. Viability was an invention of the Supreme Court. And then it says here, just to give Hammond's history, that after his clerkship was done, he joined the Watergate Special Prosecution Task Force. It's funny how all these things are overlapping. He ended up finally with the equivalent of the Innocence Project in Arizona. On to Chapter 13. We may be doomed to come to an agreement today. So it's going back to the peace agreement, and it says under no circumstance would Thieu, the South Vietnamese leader, recognize the legitimacy of the Viet Cong, even though they would be a signatory to the agreement. And Thieu would have to deal with leaving North Vietnamese Viet Cong forces in place in the South in enclaves that would be monitored by the Joint Military Commission. So the general approach was to start with an announcement that the United States had halted its bombing in Vietnam because of progress in the talks. And then Nixon started to worry about who was going to get credit, and he did not want Kissinger to get the credit, and he was freaking out over it. And he didn't want Kissinger to make an announcement first, because then Nixon's own announcement would be anticlimactic. And Thieu was still dragging his feet, and it said, Kissinger said, it must be clearly understood that when we conclude here, we must proceed to an initialing. Whatever Thieu's answer is, under no circumstances will Hanoi hold still for a repetition of October or for a renegotiation without blowing the whole agreement. And it gets into the nitty-gritty of the agreement, but we do know that eventually it was signed. And funny, the chapter ends with, because of the widening Watergate scandal, the Miami Dolphins did not make the traditional celebratory visit to the White House later that summer after they won the Super Bowl. It wasn't until August 2013, 40 years later, that they finally made the trip at the request of President Barack Obama. Now, chapter 14, entitled LBJ Got Very Hot. And the overarching thrust of this chapter is that Nixon wanted to distract from Watergate, or he wanted the Democrat Congress to become worried about another scandal of similar type that might affect them, so that they would just call the whole thing off. And that would be Nixon's suspicions that his plane was bugged by LBJ. And if he could somehow throw shade at LBJ, remember LBJ was still alive at this time, that would pressure the Democrats. It said the strategy du jour to neutralize Congress on Watergate found its origin in Nixon's longstanding belief that his campaign plane had been bugged by LBJ during the 1968 election. He'd been told so by J. Edgar Hoover himself, but J. Edgar Hoover could not be the source, so he was really scrambling to find another source that could corroborate. It went back in the narrative to the Watergate hearing, and Hunt, after opening statements, wanted to plead guilty to only some of the counts. That was denied by the judge, so then his attorney did plead to all of the accounts. But funny, Soroka afterwards tried to force Hunt into telling him who higher up was involved. But his attorney protected him, saying that it would imperil Hunt's future grand jury testimony and the remainder of the case at hand, so the judge backed off. Because of that discussion and Hunt pleading guilty after opening statements rather than before the jury was impaneled, the rest of the attorneys tried to get the case dismissed on a mistrial, but they did not succeed. So it says, And remember, Nixon thought LBJ bugged his plane, but LBJ thought Nixon committed treason for undermining LBJ's own peace negotiations in October. Let me read these 2 paragraphs here. If true, and it seems likely given all circumstantial evidence, this activity by the Nixon camp completely undercut the Johnson administration's negotiations in Paris, which after long hard months had resulted in an agreement by Le Duc Tho and the North Vietnamese to accept South Vietnam's direct participation in the Paris talks, provided the United States stopped all bombing in Vietnam. When Thieu would not go to Paris, LBJ halted the bombing nonetheless because he felt he had made a deal. The failure of these talks ensured that the appalling conflict and loss of life would go on for an indefinite period of time. Johnson told Everett Dirksen on the evening of November 2nd that he considered the actions of the Nixon campaign to be treason. Ironically, 4 years later, Nixon was trying to find ways to use the Johnson wiretaps and surveillance to obstruct the growing Watergate investigation at the very moment Nixon was finally bringing the bloody war to its ambiguous conclusion. Okay, that is it for those 3 chapters.